Good evening to everyone present here. I, Avneet Gaur, member of Sambhav Initiative and moderator for today's session. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Ms. Pallavi Pratap ma'am, and to all the participants in this 2 weeks national capacity building program on family laws, code practice, procedure, and drafting, jointly organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, and creating legal literacy under the direction and guidance of Patron in Chief of Sambhav Initiative, Honorable Justice C.K. Thakkar sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Justice M.R. Shah sir, former Judge of Supreme Court of India, in collaboration with Pro Bono India, which is working towards legal aid and legal literacy, where today's session is all about maintenance and alimony. It is my privilege and honor to introduce our own expert board member of Sambhav Initiative, Ms. Pallavi Pratap ma'am, a distinguished legal professional and managing partner at Pratap and Company. Ma'am is an advocate on record at Honorable Supreme Court of India, and ma'am regularly appears before the Supreme Court, various high courts and specialized tribunals including NCLT, NCLAT, NCDRC, NGT, and CAT. A recipient of the prestigious 40 Under 40 award by BW Legal World magazine, ma'am was also recognized as the top advocate on record for the year 2024, a testament to her excellence and impact in the legal fraternity. Before establishing her practice, ma'am was an investment banker. Ma'am holds an MBA in Finance and Marketing from La Trobe University, Melbourne, and has also undertaken a research project on performance measurement system, a comparative study between SMEs in Australia and France. Over the years, ma'am has represented a wide spectrum of clients, including private individuals, public sector undertakings, corporates, and even state governments. Her work spans litigation, compliance, intellectual property, corporate strategy, and legal literacy. Apart from her legal career, Nam is also the chartered president of Rotary Club of Delhi, Lotus, actively contributing to community welfare. We are deeply honored to have you with us today, ma'am.
Thanks, Avneet. And thank you, Dr. Kalpesh, for having me here and everybody at Sambhav Initiative, because I think this is the second time that I'm actually addressing. I think I did it last year also on criminal law, was it? Last year, I think it was on the criminal law part of it. So this year's topic seems to be very interesting because I think this is the need of the hour. Just now, I think after the COVID, you know, COVID-related lockdown, we saw a surge in all these matrimonial cases. As a result of which, I think there has been an increase in a lot of divorce cases, separation that we see. And also, we have noticed that senior citizens are also claiming maintenance from their children. So today I've tried to balance out between not only alimony and maintenance for a wife, but I've also tried to cover maintenance with the perspective of a senior citizen. That is, maybe it could be a parent or a grandparent, things like that. So can we go on the next slide, please? Right. So I'm sure I'm not able to see how the details of the participants, but I'm sure everybody would have an understanding of what is maintenance and what is alimony. But I will still start with trying to answer it to the best of my ability. If there are any questions that everybody has, they can always keep writing it in the chat box, and either I will try and answer them as I go, or I will then separately take it at the end of the session. So maintenance and alimony, primarily, what is maintenance? Now, maintenance is something which is given on a month-on-month basis. It could also be quarterly. It could also be, given half yearly. It is completely dependent upon the arrangement which is done as far as maintenance is concerned. Maintenance actually means that you are giving someone an allowance for sustenance, whereas alimony is something that is given one shot, given and the tie is completely over. So it is not that you have to interact with the person who's giving you alimony on a month-on-month basis. It is one shot, you've made the payment and it is over. Now, I would like to also discuss a bit about the purpose of maintenance in alimony. Now, we've seen increasingly that women in yesteryears, at least in couple of decades back, were not so, you know, they were not working, or even if they were working, it was not such high paying jobs. So they would always, depend upon their husband. So if the husband would leave them, it was important that some sort of maintenance or sustenance amount comes to them. Even though now at this age, we see that both urban and rural women are earning their own sum of money, but it is also different parameters which are looked at in order to figure out whether the maintenance amount is sufficient or it is not sufficient. If it is not sufficient, then the husband has to pay for any gap that comes between the salary of a woman and the amount that is required for sustenance. I hope if there are any queries, no, please feel free to write in the chat box. What is the distinction between an independent and ancillary remedy? Now, this is a question that comes quite often as a challenge in front of a lawyer who's practicing. See, you will always see that there are different provisions in the law which allow you to ask for maintenance, or you can claim maintenance under CRPC, under HAMA, you can do it under HMA. Muslim women can ask for other for remedy in their act itself. But what do we see? We also see that in different um, personal laws, even though the maintenance, the provisions are provided for maintenance, there is also CRPC, which is now your BNSS, which also provides you with the equivalent for claiming maintenance. Or you can also claim maintenance under the maintenance for senior citizen. And I'll be discussing all of that in subsequent slides. So you will see that there are independent ways of asking for maintenance or alimony, and they can also be ancillary remedies, which is under not really under the personal laws of a specific community, but also under the provisions of CRPC. Can we go on the next slide, please? So, like I said, there are different key statutes and provisions that are available under which maintenance can be claimed. But typically, now this is the old section 125 to 128 of the CRPC that is mentioned. Mr. Jindal, I think you're asking a question which doesn't really involve question of law just now. Allow me to finish my points with respect to the family law. And after that, I'll be very happy to respond to your question. Now, sections 125 to 128 of CRPC basically provides for different ways in which a maintenance can be claimed and maintenance can be asked for by the wife. Now, if we just have a quick look as to what really 125 to 128 of CRPC, please mind that I'm using CRPC just now because a lot of case laws will come on CRPC. You can always have the equivalent sections of BNSS in this provision. Now let's just look at 125 to 128. Primarily 125 would talk about maintenance, which can also include interim maintenance. And this can be claimed by wives, it can be claimed by children, and it can also be claimed by parents. Now here, the gender is specified. So you will see that 125 provision will provide you with, a very clear gender protection, which is given to women or wives in this case. A lot of times, and you will be um, interested to know this also. But there was a case that I had seen in Dwarka, and this might also, in a way, answer Mr. Jindal's question, where a husband had claimed maintenance from the wife, saying that, he was unable to earn, and that because the wife was better positioned, that he should be provided maintenance. So it is not just sustenance which is gender related, but also sustenance which is gender neutral. So a man also in this day and age asks for maintenance or ask for alimony from the wife. Now moving forward with respect to 125, the requirement is that the wife, children, or the parent is unable to maintain themselves. And also here you will see that the definition of children is not really given, but that includes both the legitimate as well as illegitimate children who are born. So it could be any one of them. It is not necessary that it has to be a legitimate child only. Any unmarried daughter can ask for maintenance, and a father or a mother who's unable to sustain themselves can ask for maintenance from their children. But here, interim maintenance provisions are outlined. You have to file an application under section, basically 125. The procedure for the same is given under section 126. Why I'm still referring to CRPCs, because once you will be looking at citing case laws, you will find that this is where the case laws will be easily possible with respect to 125, 126 CRPC. Now, what is important, I did a case very recently on behalf of a husband where a maintenance amount was fixed at 15,000 for the wife. Now, what happened was with the wife that she was also already earning, and when you provide an income and asset statement, the wife did not disclose that amount. So if you're not disclosing something which is with respect to your asset or income, then the court can always reverse your maintenance that you're claiming, because then it is essentially perjury. You are not giving the correct details. Coming back to 125 to 128 CRPC, procedure is defined in 126. 127 talks about any alteration that can be done in allowance. Primarily, how it means is that if there is any change in circumstance. So, for instance, let's assume there was a wife who was really not working. She was maybe taking tuitions, etc., and she was earning some amount. She gets selected into a bank job. So then naturally, because there is a change in circumstance, the maintenance amount will change. So an application has to be filed by the husband in order to get that modified. Similarly, enforcement of maintenance can be a criminal offense also. So if you're not paying it, if you're not giving the maintenance, an execution application can be filed, and you will be bound to have your property attached in order to pay the maintenance amount. Now, here is a small trick that I want you all to remember. Rather, it's not really trick, but it is something that, usually I see a lot of lawyers forget, which is that the execution for maintenance should be filed every year. So what happens is, suppose for instance, there is a maintenance amount that is being granted. Now, what you'll do is that for 1 year, once the amounts are accumulated, file for an execution application immediately. Let us assume that, that execution is going on, another year passes by. So then again, for the revised 1 year, you must file an execution application. I have seen so many times that because of this error on part of the lawyer, the client loses out on claiming the maintenance which is rightfully theirs. The second and most important thing that I feel, and which is also in light of Rajneesh versus Neha, I'll discuss it later also. But in respect of Rajneesh versus Neha, you have to remember that whenever an execution is being filed, or whenever the amount is being asked, whatever amount you're putting in, make sure that the income and liability, the assets, the form that you have to fill, make sure that you are not deliberately trying to hide something, because it is very easy for the court to find out. So the day you try and hide something, if the other side comes and points it out, you will not only go, your client will not only suffer because of perjury, but also because um, the the intention of the judges will completely change, and they will think that you're trying to hide something because you do not want to pay maintenance. I think the idea with maintenance, and I'm trying to tell you tips as a practicing lawyer, not really in terms of the bookish knowledge that I can give you. And maybe you will see that I will be speaking more out of experience and less out of my slides, because I think that's easier. The third most important thing that you have to remember, and which is again in light of Rajneesh versus Neha, is that you will be entitled for maintenance from the date of filing of the maintenance application. If you can note it down, please do. You are entitled to maintenance from the date of filing of the application for maintenance. It is not from the date of order. So this is very important. Mind you that in any kind of maintenance proceeding, this is how you move forward. Sorry, I completely changed the topics, but I think these are three key important points that you should remember as a practicing lawyer. Now we've done section 125 to 128. There is also Hindu Adoption and Maintenance Act. There is also Hindu Marriage Act. There is also Muslim Women Protection of Right on Divorce Act. This is a very controversial act, and you will see that there are case laws which enabled for them to be receiving maintenance at par with women from other community. Maintenance and Welfare of Parents and Senior Citizen Act, and Christian and Parsi personal laws. Can I have the next slide, please? Yes, I have a question from Ishwar Singh, who says, Madam, small doubt whether maintenance increases after 1 year's filing execution application again. That's exactly what I'm saying. Even if the maintenance is not increasing after 1 year, you still have to file. See, what happens is the limitation, how does the statute of limitation works? You can only file it and claim it for 3 years, correct? So if, I mean, this is a very ridiculous example, but someone, a client whose matter was going on in the lower court, now some amount was decided, they chose to appeal, the husband chose to appeal. Now they never filed an execution. So if you're not filing an execution, or you simply are putting it, defective and leaving it, you are basically giving away your right that with a great difficulty, you've earned. So the most important point I feel is that after every 1 year, start filing an execution application for the due which is there for the last year. And mostly, Ishwarji, you will also see, at least in my experience, I have seen that an appeal with respect to any maintenance order will lie pending for at least 2 to 3 years. So, in that 2 to 3 years, if there is no stay, then I feel that execution should be filed every year. There is another question from a gentleman who says, how does the misuse of maintenance provisions across acts contribute to inconsistent calculations and enforcement lapses, particularly for vulnerable groups like parents and widows, etc.? So I'll inform you about this particular part once let's just assume when I reach on the senior citizen tribunal, because that I think is something that I want to tell you with respect to property rights also. So coming back to 125, 128, my primarily, I just informed that it has to be wife, children, or parents who can claim. And the condition is that if they are unable to maintain themselves, then they can claim for maintenance under 125. Non-payment can lead to imprisonment, but believe me, it's very rarely that imprisonment really happens, because I have seen that people will just make a part payment and get um, ahead with it. So typically, the execution really is very different as far as our country is concerned. Avneet, can we go to the next slide, please? Now, coming to Hindu Adoption and Maintenance Act, I feel this we have there are actually multiple points that I really want to discuss in this. I'm sorry, I might get a little dragged away from the topic, but I hope this will bring about some kind of lights in your head in terms of what I'm trying to say. See, adoption is one very important area where we are seeing that in India, at least, it is increasing now. Also, because the Surrogacy Act and the surrogacy laws changed, so adoption has suddenly become very widespread. Now, what is also happening, and you'll be surprised to see this, that these adoptions, a lot of times, when somebody is doing a second marriage, and if there is a child already from the first marriage, then the adoption papers are also signed. Now, let's say, and I'm doing one case which is where the wife already had a son from her first marriage, and the second marriage, the husband actually adopts the first son from the other husband of the wife. Uh, Now, divorce proceedings are going on between the current husband and the wife, and he is very clearly saying that I'm not going to pay maintenance for the boy who was born out of previous marriage. What he's saying is that it can be primarily because he was already given maintenance, and he she had received some sort of alimony, therefore he's not entitled. But the truth is that under law, because he had legally adopted the child, he's still entitled, or rather he's still um, it is the process of law that demands that he has to pay maintenance for this child also. So the misuse cannot really happen with respect to the maintenance part of it. So this obligation is always there to maintain wife, children, and parents under the Hindu law. But if the wife is unchaste, or if there is conversion, or if you're able to prove that there is misconduct, that is cruelty, etc., then you may not be entitled to pay maintenance or alimony to the wife. Now, here, the other important point that needs to be considered, especially in HAMA, is that there is a particular section which deals with factors considering to be considered in order to determine the maintenance amount. And what is that? This could be including the needs and expenses of the claimant, the income and assets of the person liable to pay maintenance, and the standard of living and other relevant circumstances. These can be considered as factors which can be used for determining the maintenance amount. But you will also see that a lot of times maintenance is also determined by the fact that if the husband has to um, agree upon by law to maintain the wife and the children at the same stage and the same standard of living as they were while they were married or living with the husband. Now, there are a few questions that have come. I'll just answer them. There is a gentleman called Kishan Kumar who says, Ma'am, I have doubt about maintenance demand by wife for wrongful gain. Then what happened when husband proved this? Has wife returned all the money they taken from husband during proceeding? You know, I have really not seen any such case. Maybe, and I don't think that I have come across something like this, but I do have come across a case where, you know how it is that when you are filing for divorce, and on a mutual consent basis, and you have your 13(1)(a) and 13(1)(b) on the first date of your mutual consent divorce, the wife says that you pay me XYZ amount. There is a settlement deed also. I will sign it. I will take this amount as a full and final alimony payment. And on the second date, I will give you divorce, which is primarily how, if any of you are practicing lawyers will understand, that's how mutual consent divorce works. So the husband gave the demand draft of some 6 lakh rupees towards the wife and the child who was there as permanent alimony. I think that was very less, but in any case, that's what he gave. So then, when the second hearing, the second motion date came, the wife refused to give divorce. She said that this is too less of an amount. I don't want to settle. So then the husband filed for a contempt. The matter went in an appeal also. And the judges said that even though she's taken some 6 lakh rupees, but considering that the amount is less for a child, for his entire education, marriage, etc., and for the wife to sustain for entire life, therefore they were allowing. But I've also seen cases where if a wife has taken money and then refuses to grant to give divorce, then it is naturally considered as contempt of court, and the wife may be punished accordingly. Uh, Arun Jindal, in this particular example, can husband refuse to adopt? See, I think you've not understood what I'm trying to say in that specific example. Nobody is forced to adopt. You want to marry someone and you are requested to adopt someone, but you refuse, that you don't want to adopt a child, then nobody in this world can force you to adopt. If you're adopting, then you're adopting after understanding that you're an adult and that you can take those decisions yourself. So nobody in this world forces anybody to adopt, because there are adoption deeds which are prepared, and that adoption deed contains all these clauses which one has to fulfill. So I don't think anybody is forced to adopt. They adopt out of their own willingness. Should they not want to adopt, they can always say no. It's not the end of the world. Now there is another question, madam. Are if the Mr. Jindal, if there is no adoption that is done, then how can maintenance liability come? Now you please have to also apply your brain now. Don't ask questions which, there is a um, natural extension to everything. If I don't adopt a child, how is it that I'm supposed to pay maintenance liability for that child? If I adopt someone, then of course my liability arises. Now, there is another question. Why is there no fixed formula for calculating maintenance under relevant laws, leading to judicial discretion? Array, there are so many of these judgments. There is that KM Joseph ka judgment. No, sorry, Kurian Joseph ka judgment, where he very clearly says that a husband has to uh, pay 1/4 to the wife and 1/4 to the child as far as maintenance is concerned. And he says that 1/4 is for that person's own sustenance, and the other 1/4 is for the parents of that person. So primarily 1/4, 1/4, nearly half of it, or sometimes 1/4 of it, depending upon the manner in which maintenance is to be calculated, has to be paid. There are katina of judgments, Mr. Rafi Uzama. You will see, if you even go on SCC online, you'll find those answers there. Mr. Anand has asked, once the maintenance amount is finalized, can the wife file for increase of maintenance amount after or anytime? Yes, yes, absolutely, Mr. Anand. A wife can file for modification of that maintenance amount. As a matter of fact, a husband can also file for modification or alteration of that maintenance amount, should the husband have details that there is a possibility that the wife is earning more and does not require maintenance. So the alteration of maintenance amount can be done at any given point in time. But then it is just like a suit. It will then, be fought on evidence, etc. Can we go to the next slide, please? No, there is no excessive harassment. If a husband can file for an or modification of the maintenance amount, saying that, okay, I think these changes in circumstances taken for the wife, that's not harassment. Or if the wife says that no, husband is earning much more, and there is no, please also understand, maintenance is not necessarily given after divorce is granted. So it is only for that specific period. Even though I've come across cases where maintenance is being given for the lifetime, which I completely don't understand how, because if the alimony is already given, maintenance should not be paid for the rest of the life. I think that's just not correct. Madam, can a valid adoption be cancelled by mutual understanding by the parties? Karuna, I have come across a lot of cases like that. But I'm not sure if that really works because uh, how do I say this? If there is a if there is a possibility for a cancellation of an agreement, because this is adoption, this is really not an agreement in that sense. um it's slightly tricky. In my experience, I can only tell you what I have experienced. Maybe my experience could be limited also, but I do know that there was a contested case where the husband finally said that, I don't want to keep this adopted child anymore. Is there a possibility, because of XYZ reason, and he had filed a writ in the high court, and that's how the adoption deed had come about to be cancelled. But other than that, you can have your uh, declaration filed. You can definitely have the mutual agreement. Through mutual agreement, it can be cancelled. But the validity of it, Karuna, I've not come across any case such as that. So I may not be the right person to answer on that. So if you do get to know the answer, do tell me about it. There is another message that has come. Good evening, ma'am. Can maintenance be linked to visitation to child if access to child is constantly obstructed? This I think is happening quite a lot. Even I see it with my clients, that the access to the child is denied because the maintenance has not been paid. But the access which is granted, especially with respect to custody, if you ask me, is given under Guardians and Ward Act. It is not necessarily given under the maintenance, this thing. So you can always file for a contempt if the visitation of a child is hampered with. But believe me or not, the judge is going to ask you that why is it that you're not paying the maintenance, even though they are separate proceedings. I'm getting so many questions. I think my slides will remain. I have only 25 minutes now. Very quickly, I'll take Tanish's this thing and I'll run through my slides. Ma'am, it's not good morning, by the way, Tanish, it's evening. I hope you're in India. If you're abroad, then I understand good morning then. If husband is unemployed and divorce is under process, if husband is unemployed and divorce is under process and wife demanding alimony or maintenance, can court may grant judgment in favor of wife even if judge? See, the case law is very clear. Uh, the court says that if a husband is an able-bodied person, then it is his duty to maintain the wife and children. And I think every second case that I see of men who have, salary of 50, 60 lakh rupees till such time that they were married, and the moment divorce case is filed or maintenance is filed, they suddenly become jobless and they are working for 3,000 rupee in a store. So those things, unfortunately, I come across quite a bit, and I think the judges also sense it. So if somebody is trying to lie and say that no, I am only earning 3,000 rupees now, the judges are also able to sense. But if they really think, and I have come across a case where a husband had become paralytic, so then the court said that, of course, it is difficult for that person to pay the maintenance, etc., and had then did not pass any orders with respect to alimony. Uh, as for maintenance in reverse, if wife is employed, yeah, so many times it is happening now that the husband can ask for maintenance in reverse. After all, we are living in a equal world. So I think these days men also ask women for alimony. I'm not surprised. Um, so now let's come back to Hindu Marriage Act. Section 24, interim maintenance, and Section 25 is permanent alimony. Interim maintenance primarily is when there is a case which is going on under Hindu Marriage Act, which is, let's assume it's the divorce case which is going on. Then till such time that the divorce case is finalized, and interim maintenance is to be granted. But in case the divorce is finalized, then under Section 25, a permanent alimony can be given. Now, here, I think both men and women will be happy that either spouse may claim for this provision. It's just that you have to prove that you are incapable of earning at any given moment. Now, this could be a lump sum amount, or it can also be periodic payments. But I have also always felt that a periodic payment is so much better than lump sum amount because, um, and this I'm talking about maintenance, not really alimony, because uh, it keeps coming, even though it creates a lot of headache that maybe one month it will come, the other month it will not come. But alimony should always be one time so that all your ties are cut off and there is a clean slate. There is also one very interesting article I read a while back where it said that men these days are taking loans in order to pay their maintenance or alimony amount, and that sometimes appears to be true. The reason is that I think the courts have become at any stage. For instance, I'm 35 and I have a wife and I have a child also, and the court tells me that I have to pay 50 lakh rupees in alimony. What is it that I'm going to do? I will take naturally loan and pay it off in order to move forward with my life. So these are the kind of things that I've seen a lot, and it was quite shocking for me, but I think that's how people in India are, you know, sort of handling their alimony and maintenance kind of orders. Can I go to the next slide, please? Can a husband seek help from court saying he's ready to pay alimony, but not in one single installment, but in some installments? So then, Sumit, what really happens is that, see, there is always a distance between the lip and the cup. So the court also, by way of abundant caution, will say, okay, if you want to pay it in 10 equal installments, then you can pay it in 10 equal installments. The divorce will be granted after the final payment is done. Or otherwise, leaves it will observe in the decree that even though it is being paid in installment, should there be any installment which is not paid, then a contempt of court can be initiated against the said person. Vasanta, can I just reply to your question in a bit because I want to finish my slides also. We barely have some time. Now, Muslim law is where I also wanted to discuss, and I think there is a very interesting movie which is coming up on Shah Bano case. I think Yami Gautam is the actress, and I'm really looking forward to watching it. But Shah Bano case was a very interesting case. This lady was married for about 43 years to her husband, and the husband was paying some, I think at that point in time, 200 rupees or something out of his own volition. Then he reduced it to 79 and then he completely stopped paying it. And in the I think the court then ordered for 79. That's how he was paying 79. And then obviously he stopped paying the 79 also. Then the Supreme Court ordered some 100 something rupees This, I think we are talking about 85, 86. And once that order came, uh, the government at that point in time had then brought about parliamentary amendment to the act and said that the husband is only liable to pay during the iddat period, which is after um, the separation period after the divorce, I think, is finalized. I'm sorry, I'm not very well versed with Muslim law, but I think it is that. And once that and it is only maintenance amount that is to be paid only during iddat period by the husband. After that, the husband has absolutely no role with respect to paying any maintenance amount. Now, this was then, like I said, the parliamentary amendment was brought about, and the change, they made sure that only the iddat amount payment was to be made, iddat period payment was to be made. After that, the lawyer in the Shahbano case was a gentleman called as Daniel Latifi. So then he filed a case in, I think, the late 90s, around that time. And he, in 2001, came up with the Supreme Court judgment which said, and very clearly it said, that the Muslim women are to be treated at par with women from other communities and that they should be paid the exact same maintenance amount as is to be claimed by women from other communities. And it also said that if after the iddat period, the woman doesn't remarry and is not able to maintain herself, then in that case, the husband still has to continue to pay. In the event the husband is not paying, then the child, um, children, or any of the relatives, the woman can claim. Can we go to the next slide, please? And yes, there is another important point, which is that 125 CRPC applies here also. As a matter of fact, it applies for every single citizen of India, and not necessarily governed by religion, caste, gender, anything. Gender, yes, with respect to wives, but I think there are one or two cases where I've seen, specifically in domestic violence, where uh, the husband has filed a domestic violence case against the wife. Now imagine, how does the Domestic Violence Act read? It reads as protection of women from domestic violence. But there are also men who are filing under domestic violence and getting orders. This had happened in Dwarka court in Delhi. I'm not sure what is the stage of that order, whether that order has been appealed or not, but the husband had very successfully claimed maintenance. As a matter of fact, I'm sure you all would have read about the latest case that Malvika Rajkotia ma'am had argued in the Delhi High Court, where they say that a wife can file a suit for damage against let's say the husband is having an affair with another woman, and um, if at all that affair goes on and this wife is left, she can file a suit for damage against that woman and claim for the amount. So those are the things that are also happening. It's a very recent judgment of Delhi High Court, and I think that can apply gender neutrally also. So you can read that judgment. If I find it, I'll have it sent. Mr. Jindal, I understand that a husband cannot file it. I am talking about one off case which was there in Dwarka court in Delhi, where a husband had very successfully filed for a DV case and an order was also passed for him. But this is one off case, like I'm saying, and that is why I was telling you that PWDVA stands for women, but a husband had filed. It is a one off case, it's an exception that I'm talking about. Can we move on? Sorry, thank you so much for this slide. Maintenance for parents. Maintenance and Welfare of Parents and Senior Citizens Act 2007. Now, this is an important act that I also want to talk about from the perspective of not only daughter-in-laws, but also from the perspective of mother-in-laws. A lot of times we are seeing that there is this concept of shared household, where now a woman a daughter-in-law can claim that because it's a shared household, she should be allowed to live in a particular house. And so we see that under DV Act, because of the shared household concept, the in-laws are a lot of times, you know, thrown out of that house, which in some cases may be that of the mother-in-law. So, for instance, I'm doing a case where the mother-in-law has a house, which was her own house that she had built after a few years after her marriage. The daughter-in-law comes and says that I have got a protection order now. I have to live in this house. And so this elderly mother-in-law, along with the father-in-law, had to move out. And then she kept fighting, but then because of that protection order, which was given on, I feel, false evidence, she was, I think she's been out of that house for 6 years. Now the case is going on. However, what the mother-in-law did was that she then went to the senior citizen tribunal and got herself a protection order saying that she has the right to live in that shared household because that is her house. She's the one who purchased. Now that case is actually pending before the Honorable Supreme Court. We are fighting it. And that will hopefully clarify that when there is a conflict between a domestic violence act, a protection that is granted under DV Act, and a protection that is granted under Senior Citizen Tribunal Act, which will prevail and which is the one that will, be looked upon. See, there is a concept of something which is called as non-obstante clause, and I'm sure you all know about it, notwithstanding clause. And also any act which is later in time will always have prevalence over the act which is previous to it. So typically the argument will always be that the Senior Citizen Act is, because it is later in time, should prevail upon DV Act. But still the Supreme Court has taken cognizance of it and is going to revisit and see as to how some sort of a balance can be made between the two. So can we go to the next slide, please? And these are other personal laws. So we've talked about, Indian Divorce Act, which is for Christians, Parsi Marriage and Divorce Acts, which is primarily for Parsi, Special Marriage Act for people who are from different communities who are getting married under the Special Marriage Act. And there are also, we are seeing different gender applicability, which is also coming across. As a matter of fact, I think it was yesterday only where a woman was trying to claim maintenance from her live-in partner. So the court very clearly held that you cannot claim maintenance from a live-in partner. That has to be claimed only if you are married. So to cut a long story short, the misuse of law by any gender, the court is easily able to see it. And there are so many instances that I see where, for both the genders, it is difficult to get justice because I think at the end of the day, maintenance and alimony is all about who blinks first. And that is the reason why we see that it has these changes that come in. Can we go to the next slide, please? I think we've talked about these eligible claimants, but here I also want to talk about the widowed daughter-in-law. Now, this is one area where I think increasingly law is getting settled, where if there is a daughter-in-law which is widowed and the in-laws don't want to keep the daughter-in-law or provide her anything, then that lady can fight for her right and get the eligible claim which is available under so many different laws in the country. Can we go to the next slide, please? So this, I think we've talked about. We've talked about interim maintenance, which is maintenance pendant lite or maintenance pendant light, as a lot of people say. Post-divorce, which can be permanent in terms of alimony. independent claim under CRPC, and revision and modification is possible. To answer Mr. Anand's question, either of the spouses can ask for revision or modification. Can we go to the next slide, please? This, I think, is something that I've always wanted to discuss. In terms of Rajneesh versus Neha, it has become mandatory now for both the parties to disclose their income, assets, and liabilities. So, this is where you have to make sure that you have everything very clearly written out. Now, and this is where a lot of lawyers play their games also. A lot of chartered accountants I see play their games in terms of ITR filing, etc. I mean, and that's how we see that sometimes women who are earning a lot of money will not show it in their ITR and then claim for maintenance. Or men who will not show that they are earning money, they will take it in cash and then try and avoid maintenance or alimony. I think this is where I see a lot of creativity from lawyers or a lot of hiding from lawyers. As a matter of fact, I'll tell you a very interesting order that I read, and I just challenged that in Supreme Court. I got a very good order in that also. So my client, who's a husband, was sitting in the court when the maintenance order was being passed. So the judge says, and there is no income asset liability certificate, the form which is being filled by the wife. The husband is only provided. The judge says that looking at this person, it doesn't look like that he's a coolie because he is wearing proper clothes and he has a watch in his hand and he has a smartphone in his hand. So he clearly doesn't look like a coolie. As a matter of fact, he says that he's a coolie in a computer center, but I don't understand how there can be a coolie in a computer center. So now I am sure you can understand the kind of story that was built up. My argument was that a judge cannot um, decide a maintenance amount basis looking at a person. There is a reason why income asset liability forms are being filled. So you have to look at that and then decide whether or not a person is eligible. Uh, and that, I think, did ring a bell, and hopefully I think actually we got a good order in terms of modification for maintenance amount. So that was really good. Can we go to the next slide, please? Good evening, ma'am. In case an interim maintenance is ordered and then that interim maintenance quantum is challenged in the High Court, will the interim maintenance be stopped or will it continue till such time that the... See, if there is no stay, then you are bound to pay that interim maintenance. But if there is stay, then of course you are naturally not bound to pay for that interim maintenance. But I have seen a lot of times that people don't pay that interim maintenance, and then the court orders that you pay 50% of it, and that's when they pay. So I think it's more to do with what your lawyer is advising. But the truth of the matter is that if there is no stay, you are bound to pay that interim maintenance. We've already we've already discussed about these judicial trends. So I think this part is covered with. I think that should be all there. This should be sufficient. Is there any more slides which are left? I'm sorry, I don't remember. Abneet?
Ma'am, there's just illustrations and practical tips only.
Oh, okay, all right. So that I think we've already discussed that there is no, because of the questions that kept coming, I think I've already discussed those. There are no fixed formula. Oh, Vasanta's answer needs to be done. Sorry, I'll let Vasanta just let me go through it. What is your say on claiming maintenance by working or salaried wives? Now, for instance, if like I think you guys would remember, there was a case which had happened before Justice Gavai, where the wife was claiming some X amount because the husband was getting a lot of money. I think he was making some 12 or 15 crores every year. And so it is primarily dependent upon case to case basis. If the gap is really high, then clearly maintenance or alimony in proportion to whatever the husband is earning is important. But if it is not that much, then I also personally feel, um, rather, I'll tell you about my life. I mean, while my divorce was going on, I never got any maintenance. Neither did I file for it. And also for alimony, I got some 10 lakh rupees for a 10-year, 13 years of marriage. So I think to each their own. I never felt that I needed uh, money from my husband because I thought I can make it on my own. But, to each their own. There are three more questions. Um, I have one more lengthy question. Can I ask directly? Vasanta, just write it down. If I have enough time, I'll try and answer. Otherwise, I'll try and do something else. Maybe reply over an email. Nowadays, there's a tendency of asking huge alimony while the wife is working. This has become a nuisance, by the way, Anandji. I'll tell you that honestly, everyone after 3 months of marriage is asking for 1 crore as alimony. I don't seriously, being a woman, I don't understand how that 1 crore of alimony can be justified. Because it's just been 3 months of marriage. There is no child born out of it. But that's how the world is going. And there are people who are paying it also. So who am I to judge? Um, Whether father-in-law of a widow is having an obligation to maintain her, definitely, Karuna, it is there. As a matter of fact, that is definitely provided. With respect to, there are katina of judgments that have come from Supreme Court defining this. But sometimes, Karuna, I feel that a lot of judges in the lower court also decide matter based on particular facts and circumstances. They don't really go by the precedents of law that has been established. So sometimes it is it's a tightrope to walk on. Ekta says, what can be done if interim is pending from 3 years for hearing despite High Court's expedite order and income affidavit is full of false statements? What adverse view can be taken? See, if there Ekta, I can just suggest you something. This looks like probably an Allahabad High Court tendency. I don't know if it is Allahabad High Court or whichever. But what you can do is that if there has been it is pending for 3 years, then you take out all those orders where only the one about the Mumbai family code. I'm not surprised. 3 years for hearing in the Mumbai family court, and High Court gives you an expeditious hearing order. You take out all the orders of adjournment and then move an application in the existing expeditious hearing order. You will not get any order from the Bombay High Court, this much I can guarantee. But use that order and go to Supreme Court and get a direction. You'll see within 6 months your matter will be done and over with. Mamta Sharma. Good evening, ma'am. In maintenance, who are counted as relatives who can ask for maintenance? See, typically it is your blood relation. So you can ask from your father, mother, mother, which is a rarity, father, brother, that is who are counted as relatives as far as maintenance is concerned. I think that's been quite a bit. It's already 8 o'clock. So, Dr. Kalpesh, if I can have your leave.
Yes, I
Uh,
can say, man, highest number of questions been asked in your session. So it's
It's actually
very
better to answer queries because all of us are lawyers here, no? So we always have the same questions that how should one, and this is just my experience, sometimes my experience may be totally wrong also. It's all case to case basis. So, but I thought that I should just share about my experience.
true.
uh, Thank you so much, ma'am. And on behalf of the organizing committee, I extend a sincere gratitude to you, ma'am, for such an enriching session today. We are truly thankful to you, ma'am, not only for accepting our invitation, but also for taking the time to guide and inspire all the participants. Thank you so much, ma'am.
Thank you so much for having me here.
Thank you, ma'am.
Thank everyone. Take care.
Thank you.